Hi there, I'm James Dapperchi, and this is Coffee on a Case Note. The New Year's arrived, guys, and what better time to talk about that most fascinating of New Year's subjects, corporate oppression. We're back to our happy hunting ground. This is a decision called Munstermann and Rayward. Right, so we've got a corporation. It is solvent, and it's operating a business up in Brisbane. We've got two directors, and those two directors are also the two shareholders in the company. 50-50 shareholders, two directors, two people. Yeah, easy. One shareholder director is up there running the company in Brisbane, and one shareholder director is down in Sydney, not assisting the company due to illness. Right. Our Sydney director, pardon me, our Sydney director makes an offer to sell his shares to the Brisbane director. He wants to get out, he wants some money, he wants to move on with his life, and he's ill. And in short, our Brisbane director says, no, not at that price. And so following this, what happens is our Brisbane director begins to engage in some conduct that was of considerable interest to the court in this matter. And some of you know I don't like using notes, but I thought this was worth a few notes. So we might just work through the conduct that our Sydney director engaged in. Forgive me. So firstly, our Sydney director attempts to be reinstalled as a financial controller of the company, notwithstanding the fact that they're already employing someone in that role who's doing it also at a lower salary, substantially lower salary than our Sydney director is chasing. Our Sydney director issues an invoice for $16,000 worth of consulting work that he agrees, firstly, was not requested, and secondly, no work had actually been done. And what he ends up agreeing in cross-examination is that, yes, the invoice was just a bit of a try-on. What else does he do? This one's fun. He requires that all payments to be made by the company, including staples, had to be agreed and approved at minuted directors' meetings. He sends an all-staff email, it's pretty alarming, to the effect that the company has insufficient funds to pay wages and super. And generally, this is a suggestion he accepts in cross-examination. He holds the company at ransom so he could get what he wanted. So this is the conduct. Can I refresh your memory on the law of oppression? And we spoke about it last time we were having a coffee in this coffee shop. There's section 232 that says if there is commercial unfairness, and commercial unfairness is really broadly defined, then the court may make an order pursuant to section 233. And section 233 sets out a broad range of orders that might be made. The sections we're talking about are of the Corporations Act, don't forget. So what we find in this case is that the 232 test, commercial unfairness, tick straight away. All these sorts of things that I've just read from my list that our Sydney director gets up to satisfy the 232 test. So the court is then empowered, it has a discretion to make an order pursuant to 233, and those 233 orders can be all sorts of different things, but broadly speaking, two of the big ones are wind up the company, bring it to zero, or cause a sale of shares to be made, order that the shares of one shareholder be sold to another or some other shareholders at some price. Now, in this case, the company's solvent, it's ticking over, it's employing people, and so there's no value seen in winding up the company. And what the court orders instead is that our Sydney director, our bad guy, quote, quote, our oppressive guy, certainly, is ordered to sell his shares to our good guy, quote, quote, our Brisbane director, at a value that has been ordered pursuant to valuation evidence that came before the court at the hearing. Now, what you might say is, well, wasn't that the outcome that our Sydney director was looking for from the start? And the answer was yes, the Sydney director was looking for that outcome, but perhaps not quite at the value that the court ended up ordering. So what I hope this does as we ease into the new year in a nice casual way is refreshes your memory on how corporate oppression works, on how section 232 is about commercial unfairness and gives rise to the possibility for a section 233 order, which in this case was made. Thanks for joining me today. Thanks for joining me in 2019. And I look forward to sharing another copy and another case note with you soon. Cheers.